There is no wisdom save in truth. So said Martin Luther. In a significant step towards wisdom, truth has been revealed by an Australian judge, Justice Wendy Abraham of the Federal Court, in regards to euthanasia. She has ruled that counselling or promoting voluntary assisted dying via telehealth is counselling or promoting suicide, and to do so is breaking the law under section 474.23a and b of the Commonwealth Criminal Code. Now, in doing so, she has lifted a veil that has been skillfully used to obscure truth. Pro-euthanasia lobbyists can no longer hide behind acronyms such as VAD or phrases like mercy killing, euthanasia, voluntary assisted dying, or VAD as it's called. These are just other words for suicide. They involve the intent to die, a person seeking death as an out, a form of relief, and the act of deliberately gaining access to a means to commit suicide. Both lead to the deliberate shortening of life with impact on the person, their family, and their carers. The argument put forward by Melbourne Dr. Nick Carr, which led to this case being considered in the Federal Court, that euthanasia should not be considered suicide, is an insult to logic. Consider the Queensland man who recently committed suicide by taking his wife's euthanasia drugs at home after she died naturally in hospital. Same drugs, same outcome. One instance of taking the drug is called suicide, whilst another person taking the same drug is clothed in soothing words like VAD, assisted dying. But it's still suicide, a person intentionally ending their own life. VAD is suicide by another name and it can never be made safe. And this was at the heart of the judgment brought down by Justice Abraham. The case was initiated by Dr. Nick Carr, and it followed calls from a number of Australia's state attorneys general for telehealth to be used for euthanasia appointments. You see, Commonwealth law currently restricts the use of any telecommunications to promote suicide. And despite this, in states such as Victoria, Tasmania, Western Australia and Queensland, telehealth is being used for assisted suicide advice, under the guise that euthanasia is not suicide. Justice Abraham's ruling has put an end to this example of ignorance or misunderstanding, which, importantly, is not generally accepted as an excuse for breaking the law. Prime Minister Anthony Albanese has backed Justice Abraham's ruling, saying, "My personal opinion is that these issues are serious and that telehealth should not be used." Yes, it is indeed serious when you take into consideration how common mental illness is in Australia, along with the increase in cases of elder abuse, with a rising phenomenon called inheritance impatience as a significant driver of that abuse. The thought of consulting with a vulnerable patient via telehealth to discuss them ending their life should be unthinkable. Yet in most states of Australia, under the pretext that euthanasia is not suicide, telehealth euthanasia consultations are occurring with no ability to examine the patient, to see adequately any non-verbal cues, or to fully assess the mental state and capacity of the patient, or even to see who else is in the room who may be influencing the outcome. Legalising euthanasia has legalised a form of suicide. Any amount of logical consideration will always lead to this conclusion. During an interview with an ABC reporter, ACT patient Kath Dyson articulated it well when she said of VAD, "Well, I guess what it comes down to is suicide one way or another." And yet, whilst our government rightly has initiated strategies, plans, programs and research to help prevent suicide in Australia and reduce its impact, they have legalised assisted suicide, renamed it as VAD, but it's still suicide. The lie that it is not an act of suicide has been exposed in the Federal Court, putting Australian doctors on notice. All state provisions which allow for electronic carriage discussions on euthanasia are now inoperative. Anyone discussing euthanasia online, assisting someone to take their own life, including doctors and other medical practitioners, are clearly and deliberately committing a criminal offence. And those who have done so in the past have also committed offences. Even some state health websites may be illegal. In light of the ruling, as the Northern Territory and the ACT governments consider introducing euthanasia laws, they will do so in the light of the truth that they will be legalising a form of suicide that has already seen over 1,000 Australians put to death since 2019. We at ACL are grateful that truth has been revealed. It's a start in reclaiming language to once again accurately describe reality. The Bible tells us that God is pleased when truth is revealed and spoken publicly. We've called on the Federal Attorney General to follow the Prime Minister's lead and retain the current Commonwealth restriction on telehealth as a means of communication for the promotion of all forms of suicide, including euthanasia. To do any less would be to abrogate all responsibility to the vulnerable in our community. For those who live in one of our territories, there are currently online avenues for input into their plans to legalise assisted suicide. And don't hesitate to contact us if you would like any more information. In Deuteronomy, we are urged to be advocates for life. I call heaven and earth to witness against you today that I have set before you life and death, blessing and cursing. Therefore, choose life, that you and your offspring may live. It's always a good time to choose life. God bless you.